Thumbs up, that's all you guys need to know.
Okay.
We're getting ready. It's still working. I also wanted to let you know that Director Lanning is online
Okay, very good.
and we are live.
All right, well, we'll go ahead and call roll.
Senator Bouchard,
He's excused.
Senator French,
Here.
Senator DeCoste,
Here.
Senator Wasserberger,
Here.
Chairman Boner,
Here.
4 present, 1 excused.
Okay, we'll go ahead and just pause for a little bit as we wait for the prime sponsor. The only bill that we have here before us is Senate File 135 dealing with water rights on federal land. So we'll just go ahead and pause here, committee, wait for the prime sponsor to show up now that we're nice and ready for him. And yep, talk amongst yourselves. All right, Senator Hicks, welcome to the Senate Ag Committee. Feel free to present your one and only bill we have here.
Yeah, well, thank you,
Floor
Mr.
is yours.
Chairman, members in the committee. Just a little background history on this. This issue has been around for a while. I would recall back to when we had things like War on the West and cattle free in '93 and all these issues, but this really is derived out of kind of a continuing issues as we've seen administrations change in Washington DC over the years, different public land grazing policies that have come and gone. This one just goes into currently under our existing water rights laws, and not so much the water rights laws as there's a memorandum of agreement between the federal land management agencies and the state engineer's office on how stock water rights would be filed, and they can still be totally filed in the name of the agency. And that's been a little bit of an issue around the Western United States, as you can imagine over the years. What this bill effectively does is requires on any new stock water rights to be filed on any federal lands would require to be co-filed with the grazing association of the permittee. And there's a good reason for that, because under our current water laws, if you're the user, hold the water rights, you can petition to change the use of the water right. There's other venues that you could actually put that water to use in, Mr. Chairman. What this is modeled after, and I'm just going to say it, after one of the previous administrations prior to the last administration, there was several states that kind of took this up and took a hard run at it. And so Nevada, Idaho, and Utah all changed their water law as it relates to filing for stock water. Nevada's was challenged, went to the federal courts, was remanded back. They made some changes. Idaho's got some similar language. This bill is drafted based on, not all, but mostly using Utah's. And so, Mr. Chairman, that's just a little history of where we're here. We may be back to another administration that's maybe not be favorable to our public land grazing entities. It's just to try to afford one more protection for multiple use on our public lands, consistent with the water's the property of the state. And go all the way back to the McCarran Act that was passed a long time ago. It basically says the federal government will follow Wyoming or follow state water laws. So it's well within the state of Wyoming's privy to deal with this issue and go through it. But I'll walk you through the bill, Mr. President or Mr. Chairman. It's been a long day. Who are you again? Are you the chairman, the president? Mr. Chairman, members of the committee. Let me just walk you through the bill real quick. So we just go in here and we bring in some standard definitions and terminology. Just goes in under the purposes of livestock watering will only be issued, and this specifically deals with federal lands. Doesn't deal with private lands or state lands. And we did bring it in. Some of the other versions dealt strictly with public lands. We excluded that word on purpose because there's oftentimes some misinterpretation of what that is. And we do have, as you guys will see a bill coming over, we do have grazing leases on military lands also. And so that's one of the reasons. There's also grazing leases on Bureau Reclamation land. So it's not just federal land management agencies in the traditional sense of Forest Service and BLM. It would be federal lands for those reasons. So that language you see, federal agencies will now be required to file jointly with any stock water right on those federal lands. The permit only remains valid if it's put to beneficial use. This is a key component under water law. If you have a stock water right, you would think that the only way you could put it to use is if you own stock. And to my knowledge, the federal government doesn't own any livestock, maybe in a limited case. Goes in and it says under subsection B, who it can be held by, in other words, a grazing association or the permittee authorized by the federal agency to graze livestock on those lands. The water right is apperturent to those lands, so it's tied to the land like all the rest of our water under Romanet 3, Romanet 4, not changed without consent under 41.3104. And this is the change of use statutes. So under a joint filing, if an agency was so inclined to change the use, which you could go for strictly wildlife purposes, put a fence around it and deny livestock access to that water. This would preclude that from happening without the consent of the grazing permittee in that particular instance. And that's why that's in there. So you have to have the consent of the permitter that holds that the federal grazing lease. It goes in and it conditions and it says the federal agencies, no federal agency shall. We have seen this in the past for a federal agency, and particularly more with irrigation. I'm not aware of any right now in the state of Wyoming, maybe in other states, where they'll condition your grazing permit on turning over the water rights to the state of, or to the federal agency. So this is a preclusion on Romanet I, Romanet 2. And then as we flip over Romanet 3, for the purposes of watering, you still have to maintain that beneficial use. Subsection D will automatically be transferred to the grazing association that receives. So again, that beneficial user, Mr. Chairman, there is some language in the amendment that we'll get to when we get to the amendment. Subsection E, the holder of a valid permit to graze livestock has the right to maintain those consistent with any grazing agreement, allotment, or resource area management plans. Subsection F, this gets into our abandonment clause, when a water right could be abandoned. An abandonment on a Roman I, non-use is caused in whole and part by a federal agency's reductions in AUMs or federal lands. In other words, they couldn't abandon that water right just because there had been a reductions in AUMs. Romanet 2, the non-use is voluntary. We do have non-use under the federal grazing regulations that you as a permittee that have that grazing privilege through your permit can take 5 years of non-use. I think it's 3 years under the permit. Under our abandonment statutes, it says 5 years. So if that water goes for 5 years and nobody's using it for the beneficial purpose of livestock grazing, somebody could file an abandonment on that. Mr. Chairman, subsection G, nothing in this section shall affect the livestock water right. This just goes in for those water rights that we've already issued solely in the name of the federal government. Doesn't affect those or change those whatsoever. Mr. Chairman, that's pretty much the bill because the amendment is going to strike all of section 2 out of the bill.
Okay, any questions for the sponsor? Senator French.
Yes, Mr. Chairman. Senator Hicks, does this allow somebody that's got a grazing permit or allotment to maybe they've got good grass 3, 4, 5 miles away from the water source? Can they run a pipeline over there, put a tank, or can they truck water? Can they, if there's a big stream or a spring, can they get that water and truck it over to so they can utilize that? I know a lot of ranchers that I've talked to face that sometimes, depending on what their grazing pastures look like.
Mr. Chairman, so the answer to the question would be predicated on what you can do under existing Wyoming water law. So let me explain that. So you can't just go under existing state water law, you just can't go suck water out of a pond and haul it someplace else. You can get a temporary use permit under those scenarios, but you can be permitted for a water haul permit under the state of Wyoming. And with that is a routine thing that happens down in my neck of the woods in the Red Desert. They're still required to get a permit under the state of Wyoming. So it's not unusual to have a ditch or a canal or even an artesian spring. And what they'll do is they'll go in and it's a $25 permit. They'll get a permit for X number of gallons to take, put in a truck and haul it for stock water to another place. And that's pretty common, particularly in the sheep industry. So this bill wouldn't preclude that from happening because but you would have to be permitted under the state of Wyoming to do that. So the second part of your question is the same answer. You can run pipelines, but you're going to have to file a water right and you'll show where that point of use is. So if you want to pipe it from one area to another area, that's all permitted under the state of Wyoming. But when you file those water rights, you have to designate where that point of use is. So think of a pipeline that's 10 miles long. You have to show the point of use, so where every trough is at along that pipeline. So you could file a water right, take that from this point over to a different area, a different allotment, and use it under the laws of the state of Wyoming. Now, what would come in is that water is now permitted at that point of use for the beneficial use of livestock. If they wanted to somehow change that to some other permitted use, this bill would then kick in. But even under those scenarios, it was on federal lands, it would have to be co-filed. And that's the biggest, the single biggest issue here, the most important thing is getting co-filed with those livestock permittees on those water rights. Because that is, and it's been tested before in federal court, it is a property right. It's a property right under the state of Wyoming. The state vests in you as a permit holder, the right to use that property. And there's also been some tests in federal court that recognizes that you have a vested property right in that infrastructure and that improvement, that stock pond, that pipeline, and that to utilize that water. So, Mr. Chairman, I hope that answers the question.
Okay, Senator Costa.
Don't choke.
Yeah.
Thank you, Mr. Chairman. Senator, for my own knowledge, because I'm not real sure, when you have a permit, say in an area where there's meadowlands or where there's mountainous area or whatever, that you're given permission to graze on, can they put restrictions on the amount of, say, wear and tear on the creek or whatever when animals are watering there, or is it pretty much open at that point, or how does that work?
So, Mr. Chairman, as I understand, on free-flowing streams, there's a provision in stock water law or in water law that says you can call for water, but that would only be a call if somebody was an upstream user that was impounding it. So I am not aware of an in-stream flow is basically what you're asking for stock water. That doesn't exist in our law.
Senator Wasserberger.
Well, thank you, Mr. Chairman. I am struggling with the bill. I just don't understand what the issue is and what we're trying to solve. Can you explain to me what that purpose is?
Mr. Chairman, so the issue is right now, a federal agency can come in and file for that water right. Federal agency, because now they're the single holder of that water right, can also go through a change of use and change the purpose of that. Federal agency then controls the property right in the state of Wyoming, and we treat them very similar than we do every other. So this is a special protection that has been historically, I shouldn't say a special protection, but historically, anytime that you as a permittee go in on a state section and file for a water right, it's always jointly filed, and that has been the tradition. Historically, Wyoming required joint filing with the federal agencies. And then it's strictly a policy change because there's never been anything in statute. So then the policy switched, and we've said, well, we're going to allow the federal agencies to come in and file for a water right. What this takes us back to what our original policy, but puts it in statutes. But I think my biggest single concern is water is the property of the state of Wyoming in our Constitution. And you also have to meet beneficial use under the laws of the state of Wyoming. And I am not convinced that issuing a stock water right to an entity that doesn't own any livestock meets our beneficial use statutes. And so now they permit an activity out there, but we have in the past solely granted them a water right, the state's property for a beneficial use. They may argue and say, well, we've issued a permit, but typically we don't do that. We issue that to the user. And this only thing this does is codify what the historic practice, not the current practice does, but it's consistent with what we do with our state lands. And I think it establishes a consistent policy. More than anything else, I think in the big picture thing is what we want to do is we want to tie those state rights through our water right permitting system to a multiple use on federal lands. That's the nexus. Mr. Chairman, I hope that was a long, convoluted way of answering Senator's question.
So, Mr. Chairman, just a follow-up question. So is the federal government actually applying for water rights at this time?
Yes.
Are they doing it a lot?
In my neck of the woods, quite a bit.
Okay,
We do a lot of water developments, springs, pipelines, ponds, wells. And under the current scenario, now they've got a policy too that depended on, and I can't speak for every BLM district and every forest district, because what you find out, it changes from district to district to district. So there hasn't been a lot of continuity, and it'll be different from the Forest Service than it will for the BLM. In our area, out of the Rollins district, traditionally, and even currently, they'll go ahead and co-file with the permittee if he wants to. That could be changed with just a simple instructional memo coming out of Washington DC or the state office saying, we are no longer going to allow permittees to co-file on stock water on public land. And so again, we want to memorialize in statutes, which has been an inconsistent policy by the state of the Wyoming. So we've been all over the place. And I think by codifying this, we won't have to deal with these vagaries and the changing in policies. And I do think it ties a property right, the state's property, to those federal lands for a specific purpose. I do think that has some merits in protecting our federal land grazers. In the advent that we might have a hostile situation where the federal government may no longer want to permit that out there and maybe use that water for another purpose.
Okay, any further questions? Well, I have one about you mentioned the legal challenges that similar laws have faced in Nevada, and said that they've been tested and proven to be adequate. It sounds like after a little bit of tweaking in Nevada, but you said you based this bill off of something that happened in Utah. So just want to make double sure that we're ready for any court challenges that may come down. Is the Utah bill based off of the Nevada bill, or is Utah law based off the Nevada law based off that experience? Just a little bit more discussion as to that element of it.
Yeah, Mr. Chairman, and there was Nevada passed a statute in 1995, which allowed stock water permits to be issued solely to the applicant on public lands. And then the BLM had filed for those too, and the Nevada state engineer subsequently denied the BLM a water right application for water rights on BLM. It was challenged. It went to the federal court system. And I'm trying to read the summary here, but the gist of it is well, it was actually the Nevada Supreme Court held that the statute was unambiguous and allowed the BLM to qualify as an applicant. Subsequent to that, they did go back and modify that language. That was in 1995. More recent times in the early 2000s, Idaho has passed some similar legislation. And let me see if I can find the date for when Utah passed theirs, but it hasn't been challenged to my knowledge, and neither has Idaho's. They've kind of stood up under the scrutiny. It was Idaho 73-331. Mr. Chairman, I can get that information to you. I just don't have it at my disposal right now.
Just as long as we're good to go and we're modeling off that experience. I just want to make sure there's a clear connection there, since you mentioned the court case being in Nevada, but this bill being based off of Utah legislation.
And Mr. Chairman, that was the rationale for looking at Utah's, at least, and it's been in the books now for somewhere around 15 plus years. It has not been challenged that I'm aware of.
Any further questions, committee? Okay, thank you, sir. Appreciate it.
Mr. Chairman?
Oh, yeah, got you want to explain that amendment while you're up here?
So, Mr. Chairman, the most of these are suggested changes by the state engineer's office. So we can just walk through there really quick. So line 1 or page 1, line 3, delete providing perfection. And then go on down page 1, lines 4 and 5. This deals with the groundwater and springs that we're going to completely remove that section from the bill. All right, page 1, line 6, delete federal lands as specified. A lot of this is just cleanup. We'll get down to a couple of these that we did provide some corrections by the state engineer, Greg Lanning. So go on down, page 3, line 17, Mr. Chairman. We get rid of the or. His comment was put beneficial use within a time period as specified. It's not an or, you just have to put it to beneficial use. So it just modifies that as an and now. Held by a person in a grazing association, page 5, line 8. Or page 5, line 7, excuse me. After and, delete shall. And insert may. Go on down to page 5, line 8, automatically transfers and insert to be transferred, be transferred. So in other words, under this scenario, the state engineer doesn't automatically transfer the water right on a stock water right just because the permittee changed. They will change the name on the record of owner. And it just says that if you want your name changed to the new permittee or grazing association, that's how you do it. You'd file for a petition of name change. It's a simple process. Page 5, line 10. Again, after land, insert by filing, this is the name of change with the state engineer. That's just changing from Ranch X to Ranch C on the holder of that water right. Page 6, line 7. Delete 3 and insert 5. This gets to under our abandonment statutes, it's 5 years. So if you don't use it in 5 years, then somebody can potentially file an abandonment on it. So it just changes that. Page 6, line 8. Again, same thing, change it to 5. And then the rest of it, we strike the rest of the bill. That's the amendment, Mr. Those were the recommendations by State Engineer Greg Lanning.
Okay, I appreciate that explanation. It's important since I'm not sure if we have the amendment out there online for public consumption. So it's good that we get out there right now. So appreciate that work. Any questions on the amendment committee? Okay, seeing none, thank you, sir. I think we have the state engineer's office on Zoom. So we'll go ahead and get started with them with their testimony.
Yes, sir. Here he comes.
Thank you, Mr. Chairman. Can you hear me?
Yeah, we hear you.
Very good. I appreciate that. Mr. Chairman, members of the committee, I'm Greg Lanning, the Director of the State Engineer's Office. I absolutely appreciate the sponsor's explanation of the bill. I know when it came out, I understood the intent of the bill. And as the sponsor mentioned, we were able to input and comment, and all the changes in the amendment do comport with the changes that I suggested, and I certainly appreciate that. And beyond that, the history does date back. As you all might know, I've been here now 14 months, and so I knew a little bit about this, but after the bill came out, I learned a lot. And so the history that the sponsor gave you was spot on. History dating back to the 70s, the entitlement or the rhetoric related to the war on the West and federal water rights on federal property. We had 2 MOUs, we still do, with the BLM and the U.S. Forest Service that have a lot of these elements that are discussed in this proposed bill. And as the senator put it, this bill then intends to codify essentially the MOUs that we've had with these two agencies in particular. There was a question related to other states and similar actions. Some of the legislation in Utah was very recently, as in terms of 2009 in particular. It's interesting, we have a draft. We've been working, the state of Wyoming's been working with the Western States Water Council. We're a member along with, I believe, 17 states. And so this has been a recent discussion in Western States Water Council as well. And then there's a draft paper that goes with some recent discussions just as of last year. And it mentions Utah, Idaho in particular. And I'm going to just respond generally to the other states. Wyoming is unique, and I think I'm very fortunate to have, when we issue permits for water rights, they are truly appurtenant to the land and not necessarily the point of diversion where you can change and transfer water rights amongst persons. It goes back to the appurtenance to the land. So in this case, stock water rights are pertinent to the land. And so names do change, but the water right and the land that it's associated with does not. And that becomes then a distinction as you compare us to other states, for instance. And so you'll find nuances in Utah and Idaho in particular, and as well as that beneficial use tied to the livestock themselves. You know, the federal government does not own cows, for instance, but it's more related to the what and the where the land is versus the use. Yes, it can only be used for grazing or for watering stock in this case, but it can be pretty much anybody's stock. And you know, it could be one lessee 1 year, but another lessee another year in terms of the stock. And so you'll find these slight differences that I think benefit the state of Wyoming. Having said all that, I'm mostly here to try to answer any questions if they come up, but I certainly appreciate the changes in the amendment, and we would have no other comments as far as this bill is concerned.
And thank you, Mr. Lanning. Any questions, committee? Senator Wasserberg.
Well, thank you, Mr. Chairman. So the question is, if we're doing this, is it necessary to codify it in statutes? Do we need to put this in statute, or do our rules and regs do the same thing?
We would like to believe that our existing statutes, of course, apply to anyone. It was mentioned, you know, be it the federal government or a private landowner, water rights, the water ownership being vested with the state of Wyoming. That's in the Constitution as well as our statutes. So we do have you know, very enabling statutes for all water rights, be they federal lands or not. Notwithstanding, that's why we developed over the years, as I understood it and I read about it, these memorandums of understanding with the U.S. Forest Service and the BLM, was to better define exactly that co-applicant relationship. When you come in for an application and it's a grazing lessee, then it requires a co-application. So I can appreciate the sponsors wanting to codify this. In this case, for instance, both one agreement comes due at the end of this year, and we would have to go back and renegotiate that, for instance. And if attitudes or opinions changed, then it may be difficult to renegotiate the same terms in the MOU. The other expires or comes due in 2 years, for instance, and would be under the same circumstances. Over and above that, these are just simply memorandums of understanding. So to what extent an MOU may protect us entirely, I'm not sure, but I can appreciate the senator codifying this in statute.
Okay, any further public comment online, go ahead and raise your hand. Thank you, Mr. Lanning, for your discussion and involvement in improving this bill. We certainly appreciate your perspective. But yeah, so anybody who's a part of the Zoom seminar, if you want to raise a hand to go ahead and provide public testimony, now is your time.
Mr. Chairman, there is no one else online.
Okay, all right, we'll move it to in-room public comment. Anybody in, Mr. McGagnon, feel free to come on up.
Thank you, Mr. Chairman. Jim McGagnon with the Wyoming Stockbrokers Association. I'd like to take just a moment to give you, from the industry's perspective, a little of the history that got us here. For decades prior to about 2010, the state engineer was issuing these permits with the name of the Federal Land Agency and the grazing permittee. And in about, I'm being a little bit not exact on the year, but I think it was about 2010, the state engineer suddenly quit putting the names of the grazing lessees on those permits. And that caused us serious concern. His position was that because of the law that's been explained to you, that the water right goes with the land, that putting permittee's name on there under Wyoming water law was meaningless. And frankly, I think he was correct. So our complacency was probably not well-founded. We brought legislation in 2012 to accomplish something similar to this. It had a little different approach. And in lieu of that, the state engineer stepped out and was able to get the two agreements with the two major land agencies that Director Lanning has referred to here. And that gave us, again, some comfort feeling. And based on those two documents, the state engineer began again putting both names on the permit. But the reality for us is that legally putting those names on there did not give us any legal standing with regards to those water rights. It gave us a comfort level, something we could use in the discussion. So the real need we foresee for this today is that by putting this in legislation, we see this as the only way that we can give a legal standing to that permittee being on that water right, so that the federal land agency can't deny the use of the water or divert it to a different purpose without the approval and agreement of the permittee, who's a co-holder of the watering right. Excuse me, Mr. Chairman. So with that, Mr. Chairman, we're very supportive of this bill and the amendments. I do have one minor question with regard to the amendment that I'll be happy to visit with the sponsor later about. We don't need to take up time with here now, but with that, we would urge your support for the bill. Be happy to take any questions.
Any questions for the stockgrowers? Okay, thank you, sir.
Thank you, Mr. Chairman.
Any further public comment? Mr. Moline.
Brett Moline, Wyoming Farm Bureau Federation. Ditto. Farm Bureau supports this bill for the reasons outlined by the sponsor and Mr. McGagnon. And with that, Mr. Chairman, I'd sit for any questions.
Okay, any questions for the farm bureau?
Just want to make sure you understand that we support it. So thank you.
Yeah, thank you, sir. Any more in-person comment? Okay, we're all set. Okay, going once, going twice. Public comment is closed. Committee, what's your pleasure? Moved by Senator Cost, second by Senator Wasserberger. Any discussion or amendments?
Chairman,
Yeah, Senator Wasserberger.
I would move Senate File Committee of the Whole Amendment number 1 to Senate File 135.
Okay, yep, so that's the amendment we got right here. Well, it's the amendment we have. It'll be a standing committee amendment, but yeah. Yeah, we all know what he's talking about. So, yeah. Okay, any discussion on the amendment?
Is there a second?
Yes, second by Senator Cost. So, okay, question. All those in favor, say aye.
Aye.
Opposed, say no. Motion carries. We're back on the bill. Any further discussion, committee? Okay, question on the bill. Let's go ahead and call the roll.
Senator Bouchard, he left an absentee vote of aye. Senator French,
Aye.
Senator Cost,
Aye.
Senator Wasserberger,
Aye.
Chairman Boner,
Aye.
5 ayes.
All right. Any more questions, comments, snide remarks?